Hey, I'm Paul Rabelais, and in this video, we're going to talk about the exceptions to the required 10-year payout of inherited IRAs under the Secure Act of 2019. Okay, so let me give you some background. Recently passed, and up until December 31st of 2019, when an IRA owner died and named a non-spouse beneficiary, that beneficiary could take taxable distributions over their remaining life expectancy. So it allowed non-spouse IRA beneficiaries to really take small distributions, let the rest continue to grow tax deferred, and really have an income stream for the rest of their lifetime, and allowed for a lot of tax deferral. But as of January 1st, 2020, when IRA owners pass away, completely different set of rules. The new rules require a full payout from the IRA owner within 10 years after the death of the IRA owner. Again, that's all under the new Secure Act, which stands for Setting Every Community Up for Retirement Enhancement Act of 2019, again known as the Secure Act. Okay, so in a previous video, I talked about how a lot of 50 to 55-year-olds are going to be inheriting IRAs and are going to have to take a full payout of that inherited IRA within a 10-year period. And those payouts are going to be during the prime income earning years for that 50 or 55-year-old who's going to be required to take a full payout of the inherited IRA by the time they're 60 or 65 within 10 years of the IRA owner's death. Some heavy, income tax is going to have to be paid. And then also it's just going to be a complete mess for people who designated trusts as beneficiaries of their IRA. So anyone who designated a trust as a beneficiary of an IRA has to revisit that to make sure under the new rules for required distributions, you're still accomplishing what you're trying to accomplish. So what I want to do in this video is talk about the exceptions. Who does this 10-year payout rule not apply to? Who gets to still play by the old rules? So that's what we're going to go over, and I've got all the rules here, and I want to get it just right. So under the new rules, there are designated beneficiaries who have to take, who inherit an IRA and have to take a full payout, taxable, within 10 years of the IRA owner's death. And then there are certain eligible designated beneficiaries who don't have to take a full payout within 10 years of the death of the IRA owner. So let's talk about who that is. One is surviving spouses. Surviving spouses, when dad dies, he leaves his IRA to mom. She can treat that as her own IRA, and so there is no required 10-year payout when a surviving spouse inherits an IRA. Second one is chronically ill beneficiaries. So there's a definition for that. And so this is when an IRA owner dies and the beneficiary, the designated beneficiary, is a chronically ill person. That makes them an chronically eligible designated beneficiary, and they can still take distributions over their remaining life expectancy. So there's a definition for chronically ill. I'm not going to read every word, but in essence, if you're familiar with long-term care insurance, it kind of follows, or it does follow, the when do the benefits of long-term care insurance kick in. So the term chronically ill individual means any individual who has been certified by a licensed healthcare practitioner as being unable to perform without substantial assistance from another individual at least 2 activities of daily living for a period of at least 90 days due to a loss of functional capacity. Activities of daily living are things like eating, bathing, dressing, going to the bathroom. If you can't perform 2 of those, and I think there are 6, then you're chronically ill, and you're not subject to the 10-year payout rule. Under the chronically ill individual definition, you're also chronically ill if you require substantial supervision to protect such individual from threats to health and safety due to severe cognitive impairment. So, dementia, Alzheimer's, that should allow you to meet that definition of chronically ill. And again, chronically ill people are not subject to the 10-year payout. They can take their distributions based on their age and their life expectancy. Okay, so chronically ill is one. Another is disabled beneficiaries. And we got a definition of that. So if a beneficiary of an IRA is disabled, then they too can use their life expectancy and take lesser distributions, won't have to take it out all in 10 years. An individual shall be considered to be disabled if he is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death or to be of long, continued, and indefinite duration, and it requires a physician's certification for that. So that's an exception. Okay, we got some more. We've got one for minor children, and I want to make a couple of comments on that. So let me hit that one. So a child, I'm going to paraphrase here, a child of the IRA owner who has not reached majority. So let's say for purposes of our discussion, I guess it's where the child is, the age of majority is 18. So, and let's say an IRA owner dies, they leave their child, they leave their grandchild, they leave their niece or nephew, great niece or great nephew, or just some non-relative, but as a beneficiary of an IRA, and let's say the beneficiary is 12. All right, so that was really kind of awesome from a tax standpoint under the old rules, because a 12-year-old has like a 70 or 80 year life expectancy. So if a beneficiary has a 70-year life expectancy, they only have to take out 1/70th of the amount that they were the beneficiary of in that first year. And so really kind of between a 1% and 2% distribution allows the rest to continue to grow tax deferred. And boy, the stuff will just grow and grow and grow. But now the way it works is the old rules apply when a minor is a beneficiary, but once they reach the age of majority, let's call it 18, then the 10-year rule kicks in. So there's going to be a lot of people who are minors who were named as beneficiaries, and by age 28, they're going to get a big old payout. So that's the deal with that. I never have liked it when a minor is a beneficiary of an IRA, because it just requires all of this judicial procedure stuff. A minor can't inherit, a minor can't contract. So when a minor is named as a beneficiary, we got to go through a whole judicial process to get a guardian named for the minor. And then a judge has to oversee the expenditures for the minor. And then when the minor reaches the age of majority, 18, then the money is turned over to the minor, now a major. And it's just messy, it's procedural, it's expensive, it's awkward. And so, I'd kind of like to see it where no distributions were required to be made to minors. They could wait until they were 18 to start taking any distributions, and under the new rule, Secure Act, they could wait if they wanted to until they were 28 or 10 years after they reached the age of majority. So we got an exception for minor children, and then we've got another exception for, let's see, it's the not 10 years younger exception. So let me find that one. Yeah, and it's an eligible designated beneficiary is an individual not described in any of the preceding subclauses who is not more than 10 years younger than it says employee, but I call it IRA owner. So if an IRA owner is, 74 and that IRA owner designates a beneficiary who is 65, that 65-year-old is not more than 10 years younger than the 74-year-old IRA owner. So that 65-year-old isn't subject to the 10-year payout rule. They can take those distributions over their remaining life expectancy. So those are the exceptions. It's, they're just a hassle. Our IRS code. I mean, I had to search. Says if they're this as defined by this section, and this section refers you to another section. So it's awkward. But I mean, I understand what they were trying to do. But really, what I see with this rule, it gives me a kind of a funny feeling in my stomach, because I've been helping families, and here where I work in South Louisiana, we have many of my clients over the years have worked at one of the local plants, Exxon, now ExxonMobil, Chevron. We're in the oil industry here. So many people, they completely relied as their retirement and estate planning vehicle, their company 401k plan, which when they retired, they rolled it over into an IRA. That is their only asset other than their home and their checking account and vehicles and a few smaller things. So their entire life savings is in their retirement account, and it's now in their IRA. And they have relied, for some of them for 50 years, they have relied on this concept of they're going to save, they're going to maximize what goes into their retirement account. And even after they retire, they're going to be frugal, because they are operating under the assumption that they can pass that along to their children and to their grandchildren, and know that their children and their grandchildren will get a lifetime of income and tax deferral. And that all has just been completely eliminated. So all those people who have been relying on this premise for 50 years, it ain't gonna happen. So that to me is kind of the unfortunate, and I get it. I know what Congress did. They're probably claiming this is some kind of tax neutral legislation, or maybe just a tax acceleration, legislation. But it really is going to hurt families, and its IRAs aren't going to last for much longer. They're going to last for 10 years at best. They're going to last for 10 years after the IRA owner dies. And because when people inherit those IRAs, they're in their prime income earning years. Those inherited IRAs are going to be taxed at about as high a tax rate as you're going to get. So it's really kind of unfortunate. I feel bad for those who have relied on a certain system for several decades, and then they've just been kind of smacked in the face and told never mind. So anyway, I got a lot more to talk about the Secure Act and the consequences of it. So make sure you subscribe to this YouTube channel and hit the notification bell so that you don't miss anything. It would be great if you give me a thumbs up. And then there's also a little share arrow that you can hit that button and then share it with your friends, your family, your coworkers, your colleagues who are also trying to do what they can for their families, for their loved ones who have retirement accounts, and want to make the most out of those for their families. So stay tuned. I got a lot more coming. Look forward to your comments down below. If you speak from the heart, that would be great as to your thoughts, and we'll see you next time. Y'all have a good one. Take care.